Okay, welcome everyone. Let's get started with our panel as we're running a couple minutes late. I think we got all our AV set. Welcome to today's panel dealing with FOSTA and internet censorship, one of our favorite topics here at Woodhull. And we have a great panel here today. I'm going to allow them to introduce themselves in a moment. I'm Lawrence Walters. I'm General Counsel for the Woodhull Freedom Foundation and First Amendment attorney in Orlando, Florida. I'm joined by a couple of panelists here, Ronnie London of Davis Wright Tremaine and Emma Llanso of Center for Democracy and Technology. I first want to say that thank you to Woodhull for hosting us and for conducting this conference for its 10th consecutive year. And thank you so much, particularly to Ricky Levy, who's done some tremendous things for the last 10 years in organizing this conference. And thank you for hosting us and allowing us to tell you a little bit about FOSTA and our work in connection with this matter. So Emma, why don't you tell us a little bit about yourself and CDT?
Sure. Hi, my name's Emma Llanso. I head up the Free Expression Project at a nonprofit organization called the Center for Democracy and Technology. We're based here in Washington, D.C., and also have offices in Brussels, and have been around for about 25 years, fighting for human rights and civil liberties on the internet. So CDT has been involved in some of the key First Amendment issues around the internet and keeping it free of censorship, all the way back to the Communications Decency Act in 1996 and the fighting in the Reno versus ACLU case that struck down that law as a violation of adults' right to access adult-oriented material and sexual content online. So we've been working with Ricky and with Larry and the great folks at Woodhull for many, many years on issues of protecting free expression, including sexual expression, online. And I'm really excited to be here to talk with you all about what we're seeing about internet censorship, but also eager to hear from you to see how you all are seeing and experiencing the internet in this post-FOSTA-SESTA period.
Thank you, Emma. Ronnie?
And I'm Ronnie London. I'm of counsel at Davis Wright Tremaine. I work there with Bob Korn-Revere, who is lead counsel in the constitutional challenge to FOSTA in the Woodhull case. We also do almost exclusively First Amendment litigation and counseling, a lot of internet-related and offline speech-related cases. We're located here in D.C.
And again, I'm Lawrence Walters. My law firm is Walters Law Group. It's firstamendment.com. We focus on representing clients in all manner of sexual freedom and expression, free speech issues, website operators and hosts and cam sites and so forth, and really appreciate the opportunity to address you here today. So let's dive in a little bit. FOSTA-SESTA was passed in 2018, last year in April, and there were a number of bills leading up to the passage of FOSTA, and I know that, Emma, you were really involved in following a lot of that, so maybe you can just kind of bring us up to speed as to how this monster came to be and where we are now.
Sure. Yeah. So in the years before we saw FOSTA and SESTA kind of get introduced and finally get passed into law, at least in 2 or 3 previous Congresses, there had been similar kinds of laws introduced. There had been sort of a many years long campaign around particularly classified ads websites. At first, a lot of state attorneys general and members of Congress were focused on Craigslist and their adult services section, and when Craigslist ended up closing that section around 2009, 2010 or so, a lot of the attention and scrutiny focused and shifted over to Backpage.com. And so there were many years where we saw everything from states passing laws trying to criminalize at the state level different kinds of classified advertisements having to do with prostitution and other adult-oriented services. All of those were struck down as both violations of the First Amendment and a law called Section 230, which I'm sure we'll talk a lot about later. And a lot of the attention at the federal level in Congress focused around, is there a way to hold websites like a Backpage or a Craigslist liable for the content that their users post. So if it is unlawful in a jurisdiction to engage in prostitution, could you hold the website that's hosting an ad that is or may be for prostitution kind of criminally liable for having hosted that ad? Now, a key thing to understand about the federal legal structure here is that ever since kind of the laws around liability for third-party content were set up, it has always been the case that federal prosecutors could prosecute websites under federal criminal law. This law, Section 230, shields websites from state legal enforcement and from federal civil claims. So all of the time that we saw state attorneys general looking at sites like Backpage and Craigslist, it was always possible for the Department of Justice, for federal prosecutors, to be going after these sites too. And they didn't, which was one of the big questions in the FOSTA debates about why haven't the federal prosecutors used their enforcement authority against these websites. And a lot of the kind of the best possible answer that most of us could figure out is that they realized that wasn't actually a great way to accomplish kind of any of their aims. It wasn't necessarily, going after websites was not necessarily going to decrease, for example, sex trafficking, where people are coerced into to commercial sex or are being forced to do it as a minor. Going after websites doesn't necessarily actually stop any of that kind of activity, and it more likely drives it from public websites to underground websites that are much harder for law enforcement to track if their goal is actually to intervene and help protect people rather than going after sort of high-profile websites.
And that's one of the arguments that we're making in the FOSTA litigation is that eliminating this content from the internet and eliminating the website operators is not going to help law enforcement. Law enforcement doesn't want it. Your actual investigators that are looking into trafficking and trying to prosecute dangerous individuals don't want this law because it just simply leads to the elimination of all the valuable evidence that they would otherwise be able to get access to. And it drives it overseas or underground. The overseas operators typically don't cooperate or don't as easily cooperate with U.S. law enforcement. So this treasure trove of information that they had access to in the form of Backpage and other websites that readily cooperated with subpoenas and law enforcement requests has now vanished from the internet and has inhibited law enforcement in the investigation of actual trafficking. The reasons that FOSTA was enacted and how it was kind of sold to the public and to Congress was to eliminate sex trafficking and prostitution and to force these online service providers into monitoring their content, making sure that their platforms are not used to facilitate sex trafficking and prostitution. So, Ronnie, what's wrong with that? Why shouldn't these platforms do that?
Well, I mean, I think you have to go back to the constitutional doctrine that underlies all this, because it was always the case that, generally speaking, a publisher or distributor could be held responsible for the speech that they disseminate, whether it was a newspaper, a television station, a radio station. But at the same time, going back, to the early days, in the adult bookstore cases, the obligation under the First Amendment to prove that someone had violated a statute involving either the dissemination of speech or the speech itself was that you actually had to have some kind of knowledge. And I think this is important as we get into talking about FOSTA and how it changed the law. Either you put an obligation on a bookstore owner, for example, to be responsible for knowing what's in the content of every single book that they are selling if you want to hold them responsible for selling something that ultimately turns out to be obscene or somehow otherwise violative. At the same time, while that obligation is just not feasible, generally speaking, before Section 230, you were allowed to have publisher liability because for a TV station or newspaper or radio station, you knew what you were putting on the air, you knew what you were putting on in the paper, even if it was third-party advertising, and you could be held responsible. And in the early days of the internet becoming a public good or a public venture, the first few cases kind of went different ways on whether or not an internet publisher, someone who allowed third parties to publish on their website, should be responsible in the same way that a newspaper or television station could be responsible for, say, libel or false advertising or whatever it is. And some of the cases, unfortunately, at the time, went in the direction of saying, yeah, you can be responsible just the same way. The problem is the internet is nothing like a newspaper or a television station because its selling point at the very beginning, and continues to be, the way it democratizes speech and allows anybody to have a platform to speak to potentially the entire world. Well, when you're talking about that kind of volume having the publisher or distributor be responsible for any liability that might carry that content, it just wasn't feasible. And that's how we got to Section 270. The internet would not exist as we know it today without Section 270, because if you are a website operator and you had to be responsible for every single thing that you allowed some third party to put, whether it's in a comment section, whether you're eBay and it's selling some third party product, whatever it happens to be, if you're going to be responsible for all that, your incentive to allow that kind of speech and to allow the internet to have the democratizing effect that it has had, it simply would not have happened. They would have just taken the reins back and said, no one's going to put anything on this site except for us, and whatever limited amount of additional content we are able to, I don't want to say censor, but whatever limited amount we're able to review before we disseminate it. So Section 230 comes along and says, look, if it's third-party content, if somebody else put it up, and any kind of liability would treat you as the publisher of that third-party content and you did not create it, you're going to have immunity. And so, this solved the problem of the content on the internet being so voluminous that you can't feasibly review it before it publishes, and it also solves the problem of how can you possibly charge an online distributor with knowledge that's necessary to prosecute something or to impose liability when the offense involves speech. So, and I think it's important to understand that and understanding what FOSTA really did and why it's so problematic.
Right, and the specific thing that FOSTA did was to prohibit the facilitation or promotion of prostitution using an online platform. And there's some specific problems that come along with that type of content-based restriction because as it's difficult for a website operator, platform operator to monitor terabytes of information generally, it's increasingly difficult to know when content is promoting or facilitating prostitution. The ads, for example, that were focused on by Craigslist and Backpage, you cannot often tell by reviewing an ad what somebody's intent is to engage in some specific offline activity by reading an advertisement, or you can't determine whether or not a video or a picture somehow involves an act of prostitution, somebody being paid for a commercial sex act, offline. And essentially what you're requiring these online platforms to do is to delve into the real world and to get behind the intent and the actual real world activities that are occurring when the ads are posted or when the pictures are taken or when the videos are uploaded. It's imposed a tremendously burdensome obligation that no platform can actually discharge unless they have some kind of specific knowledge that some specific user is engaging in an act of prostitution. It's usually very vague and very difficult to determine, even if you were to theoretically review every image, every text, every ad, every video that's posted to an online platform.
And even if you did, the problem that creates is it allows people to impose notice-based liability on an internet platform saying, oh, that ad or that content we believe is illegal, therefore you should take it down. And because you now have notice, you should be liable if you don't take it down. Under copyright law, we have the Digital Millennium Copyright Act, which protects the ability to post third-party content on websites. If you happen to have something that on your website that someone claims is a violation of their copyright, they send you a notice, then you're supposed to go back and take it down and send the notice to the person who posted it, say, hey, we got this claim. And if they come back and say, oh, no, it's fair use, or oh, no, I actually own the copyright to that, or it's in the public domain, you put it back up, and then it's between those two people to fight it out. You've done your duty and you're otherwise immunized so long as you follow all the rules for that. The same idea here is you can't be responsible on notice that something is unlawful just because somebody else says so, and that's one of the important protections here.
And to be frank, most websites are not going to bother trying to figure out if, and obtain good information about, oh, this is actually related to, an illegal prostitution act or to sex trafficking. What we see is just that websites, they err on the side of caution. They try to play it safe. And you run into exactly the sort of situation that Ronnie's talking about, where you have what we call in First Amendment law a heckler's veto. Basically a really easy scenario for any person to go after somebody else and say, I want your content taken down, and what I'm gonna do is assert that you are engaged in illegal sex work, and that by hosting your content, the website is promoting that or facilitating your activity in some way. When you have an underlying legal framework that says, the social media company or the website hosting company is potentially criminally liable for continuing to host your content after someone has just asserted to them that you're doing something illegal, it is a really, really heavy incentive for those companies to say, look, we don't know what's actually true, but now there is potentially a risk. So the safest thing for us to do, the thing our general counsels are telling us to do is, stop doing business with this customer, stop allowing this person to have an account on the site, because it's just not worth it to play the game of figuring out, is this really true or not?
Yeah, and the problem with the heckler's veto in this particular context, I don't have to tell anyone in this room, this country and socially, we have issues with sex, and there are people who believe that certain things just shouldn't be communicated, or certain things shouldn't be communicated outside the bedroom, or whatever their particular position is, and it becomes very easy for them to say, that's illegal, you have notice now, and you have responsibility, and if you don't take care of it, I'm going to report you to the authorities. And at the end of the day, for these websites, it doesn't matter if it is actually, in fact, illegal. Now you're imposing costs. Now you're interrupting their business. And if you don't have a good, strong immunity like 230 originally had, to be able to say, look, you have your opinion, but I'm not going to do anything about it because I can't have any liability, you really have no choice but to either put aside a whole lot of money to deal with all of the legal problems that come up, or the path of least resistance is, I'm going to stop carrying anything that anybody objects to, whether it's illegal or not. And if that was the case, again, the internet would not be what it was today.
Yeah, so any content that's on the borderline will automatically be taken down because the incentives are so tremendous to take it down. I mean, you're talking about executives and platform operators that live in a white shoe world that don't usually think about, am I going to go to prison now for operating this online platform? But now they have to face decades in prison if they get it wrong, civil claims, trafficking claims, attorneys' fees. The law has incentivized plaintiffs' attorneys to bring federal claims against the website operators that can basically shut down their company, tie them up in litigation for years. Section 230 had prohibited all that, had provided immunity. If anybody did get sued, you usually get it kicked out of court in a reasonable amount of time. Sometimes it took a little while, but now, without Section 230 immunity, the incentives are tremendous to err on the side of extreme caution. So now that we've had FOSTA with us for a year, or over a year, we can see kind of some of the damage that it has done. We saw in the beginning that countless websites and services shut down right after the law was passed, but now we've also seen financial service companies and online service providers deny sex workers and adult companies basic banking and participation in financial services. Instagram and Facebook has banned all discussions of sex and erotic content. Tumblr's taken down all erotic content. Twitter and Instagram are suspected of shadow banning LGBT community and adult users, and Twitter is now limited sharing of sensitive media. So we're seeing all these consequences where, again, it illustrates that people are sharing, the platform operators are erring on the side of caution and taking things down or limiting the transmission of content that's on the borderline. And now, Emma, that you've seen in particular the LGBTQ community affected pretty significantly by some of FOSTA's impacts.
Yeah, absolutely, and not just in the United States. So there's reporting out of Australia that it's really affected the sex worker community in that country, where a lot of sex work is lawful in different Australian states. So people engaged in totally lawful in their country activity, finding that the online platforms that they had been using, including things like Craigslist, to vet clients, to engage in their work safely, to do peer-to-peer education and safety training and information sharing, are all now shutting them down and kicking them off because so many of those platforms are based in the United States and are covered by laws like FOSTA. So one of the responses that we've seen is different sites and services kind of springing up outside of the U.S. to try to be outside of FOSTA's reach and provide services, to sex worker community and more broadly to general sex positive community or other people who tend to get swept up in content moderation around sex and sexuality, which almost always disproportionately impacts LGBT individuals. So it's this interesting tension, though, because some of those same companies that say they want to run a social media service for sex workers like Twitter, which you might have heard of or might be using, or web hosting companies that want to be really, pro sex and sexuality and not shy away from that content the way so many other services do. Those companies will also run into some of these same problems that Larry was talking about getting bank accounts, about getting payment processor companies to work with them. So it's one of the things that FOSTA has really sort of revealed, which we can see in a number of different circumstances, is just how many intermediaries are really necessary to any of us being able to express ourselves online. It's not just about does that user-facing service like a Facebook or a Tumblr or a Twitter take down your account. There are lots of different kinds of technical intermediaries and financial intermediaries behind them who also might start kind of weighing in on whether your speech is okay or creates too much of a risk. So I think one of the things that's exposed is just sort of how tenuous a lot of our ability to express ourselves online can really be, and how important it is to try to find not just sort of user-facing websites that are willing to host content, but go kind of deeper into the technical stack, make sure that domain name providers aren't going to be exerting censorship, to make sure that web hosting providers and access providers are not going to start putting a thumb on the scale and saying your content is too risky.
Yeah, and the tenuousness, that's a really important point. I mean, how easily disincentives to speech and disincentives to distribution can happen. I mean, and here's the terrible irony, or the sad part, or the terrifying part, is that all of this is happening. FOSTA has not been enforced or used once in the year and a half it's been in existence. This is all based on the chilling effect that the statute has. And I don't think I have to be that much of a cynic to believe that this is how FOSTA was supposed to work all along. FOSTA was advertised as, this is what we need to do to get rid of Backpage and things like Backpage. Let's be honest. Craigslist folded. Craigslist, nice people, whatever. But when the heat from the state attorneys general and everybody else got too heavy, Craigslist folded. The content migrated to Backpage, except for the content that just migrated on Craigslist to a different section other than adult. But put that aside, the content and Backpage, unlike Craigslist, stood on their rights, stood on the First Amendment, stood on Section 230, got cases dismissed that were brought against them by people who claimed they were trafficked, and they were trafficked. You have to use the word alleged because they were only allegations in the complaint and whatnot. But whether or not Backpage was responsible or not, they fought back statutes in various states that were designed to target it, and the attorneys general and the advocates kept saying, you got to amend 230, you got to amend 230, you got to amend 230. FOSTA was signed into law the day after the prosecution against Backpage started, and the website was seized and taken offline, and its former owners were charged in a federal court in Arizona, and its CEO entered into a plea arrangement. FOSTA has served that purpose in terms of taking down Backpage, but P.S., the charges in the federal criminal prosecution with respect to Backpage are not brought under FOSTA. They're brought under the Travel Act, which has been in existence for decades. In the meantime, FOSTA has never been applied anywhere since. Backpage is no longer operating, so of course we've solved the sex trafficking problem in this country. And all we have left now is this chilling effect, and it's truly an anti-sex, out of the mainstream sexuality statute that is designed, I think, to simply create an effect that establishes enough disincentives that there isn't going to be a safe harbor for this kind of speech, at least on services that are hosted in this country or by anyone who has assets in this country or a presence in this country. And in that respect, FOSTA is doing its job, which is, again, terrifying.
Yeah, and that's what we call the collateral damage of FOSTA. There's direct censorship by the platforms, but there's also the chilling effect on future speech. It's all the speech that isn't posted, and the jokes that aren't told, and the movies that aren't made, and the pictures that are not uploaded, all that speech that doesn't happen as a result of the fear of getting your account banned or being kicked off Instagram or Facebook, all this expression that would otherwise occur is not happening because the users are afraid and speech that is on the borderlines being taken down by the platform. So you have kind of the double whammy, and then you also have the impact on online innovation. You have the next startup that isn't going to launch because they're afraid of the liability. They don't have the money or the in-house counsel that large platform operators have. They don't have the artificial intelligence or algorithm programs that the big operators have to be able to try to identify content that might be risky or on the borderline. So they don't start up and they don't launch. So we don't have the next Uber or the next Instagram or the next Twitter. That's another significant collateral damage, and that ultimately just dilutes the marketplace of ideas because we don't have the speech that would otherwise be out there, pro and con, different ideas, educational speech regarding human sexuality and other issues. And so it's just ultimately hampered our own development and our own ability to discuss issues that are in any way erotic or sexual. Just kind of moving on to the whys of all this. We touched on this a little bit. The platforms are all exposed to criminal prosecution. Not only at the federal level, which they were before, and there were some prosecutions brought against online service providers and escort advertising sites. So the federal government already had the tools to be able to do what FOSTA supposedly allowed them to do. It had been done. Prosecutions had occurred, so they didn't really need this new statute. But now at the state level, the same platform operators are exposed to state-level criminal charges, civil lawsuits, as we mentioned. And there's also just a significant political pressure, in my view, to attack anything having to do with human sexuality. There's a tremendous anti-trafficking movement that is going on. A lot of the old censors, the old anti-pornography crusaders, have changed their stripes, have morphed into anti-trafficking groups. They've changed their names into anti-child exploitation or anti-sexual exploitation groups. And so you have this political cultural pressure to eliminate anything having to do with discussion of sexuality, human sexuality, because it's all an effort to kind of conflate pornography and trafficking and prostitution into one concept.
Yeah, we've seen that in action. I mean, I don't know, I'm sure it's come up, or at least some of you discussed the new laws in the UK and in Europe about having to do age verification for adult content, where it's so silly. I mean, you literally have to take a picture of yourself with your smart device and send it along. You have to take a picture of yourself with your ID, with the ID, date of birth, being readable before you're allowed to be given access. And we have seen people make claims in conjunction with, hey, you violated this anti-pornography statute or this gatekeeping statute. Coupled with it, we'll see, oh, and by the way, this URL, this URL, this URL, this URL, there's commercial sex happening, and you could be liable under FOSTA. You need to take it down. I mean, it's being used in conjunction with pornography, just like you say.
And it was one of the really pernicious things that happened in the legislative debate and all of the lobbying around FOSTA and SESTA when they were first introduced. So SESTA was introduced first, and it was, Stop Enabling Sex Traffickers Act is what SESTA stands for. And it started as something focused on sex trafficking in particular, and the existing federal criminal law against coercing a person into commercial sex or facilitating the commercial sex of a minor. And so, it was focused around the pre-existing law, which already had some, vagueness in it and had been expanded in a previous Congress in ways that were confusing, to say the least, about the online advertising component. But along the way, in the months of debate around these bills, it shifted and expanded significantly in scope from focusing on coerced sex trafficking to promotion of prostitution generally. And there was not previously a federal prostitution statute that was dealt with in state criminal laws. So it was this sort of significant expansion of scope of what might even be subject to federal criminal law enforcement, and a real sort of eliding of the difference between sex trafficking and coercion and prostitution generally, which is dealt with on a state-by-state basis and is lawful in some jurisdictions.
And by the way, there's still, even though there's now a facilitating prostitution offense under FOSTA, there's still no definition of prostitution.
They don't know what prostitution means. It's not defined in the statute.
They know it when they see it.
Heard that one before. Emma, what about this idea of startups being inhibited? Are you seeing at CDT, questions about the law or people being fearful of getting involved in starting online platforms?
Yeah, so I think one of the narratives around FOSTA and SESTA that groups like CDT and EFF were putting forward, that's the Electronic Frontier Foundation, who are great advocates against the law as well. We were talking about all of the different ways that it would kind of break the internet, and one of the most frustrating things in the year and a half since it's been passed is, as I work in Congress on other bills and other kind of online content issues, people are like, oh, see, FOSTA didn't break the internet. It didn't really change anything. My use of the internet is the same. And it's like, okay, congressional staffer, that may be true for you, but there's millions of people that that's not true for. Unfortunately, it's, as these things typically are, focused on voices that are already marginalized, voices that are already outside of the mainstream, or that a lot of people, including people in Congress, feel kind of okay if they get censored, if they're just not as prevalent anymore. One of the things that means, though, is that it can be really hard to track the effects of a law like FOSTA. I haven't seen as many people kind of coming out and saying, well, I had this awesome idea for a new startup, and specifically because of FOSTA, I'm not doing it. The perniciousness of a chilling effect is that you give up so much sooner than actually, coming out into saying, this is really the cause of me not pursuing something or me not expressing something. But one of the dynamics we have really seen a lot of, and I think you can kind of see this in things like Tumblr's decision at the beginning of the year to try to crack down on their bespoke definition of nudity, and content with topless female presenting nipples in it, was actually a huge pressure from advertisers. And that it's this combined factor of, if a state attorney general really wants to make an example of you and your site and crack down on you, they're at the very least going to be able to have a press conference where they make your life hell and drag your site through the mud in the headlines, and possibly also bring criminal charges against you. But there's also the kind of persistent pressure from major advertisers around, like, we just don't want our brands to show up next to this kind of content, which is, it's their brand, they get to kind of make that sort of decision, but so many of the platforms that are ad-supported are really beholden to the big advertisers being willing to advertise on their services. So it's been a lot of kind of complicated intersecting pressures that we've seen, but it's, it is very clear if you kind of scratch the surface that things on the internet are not working the way they used to, and people are not finding the spaces for their speech and for their communities that they used to have much freer access to.
Well, that's consistent with what I've seen. Part of what we do in my law firm is counsel people who are thinking about starting new online businesses. And so we certainly have seen a lot of folks come to us and say, this is what I want to do, this is my business model. And after they hear what FOSTA is and what it does and what the risks are, they 180. They're like, you know what, this is just not worth it. And obviously all of that would be attorney-client privilege, so we can't talk about the specifics, but it goes on routinely. People are not forming businesses, they're not starting new businesses directly as a result of this new law, who otherwise would have gone forward under the protection of Section 230 and realized that I don't have an issue with these potential prosecutions and civil lawsuits because I had Section 230 protection. Now it's a completely different environment, at least from what we have seen. Anything to add, Ronnie? Have you seen any of that? Okay. In terms of specific impacts on sex workers, we have seen some tremendous negative effects of FOSTA since it has passed a year and a half ago. In at least one jurisdiction, we saw trafficking actually spike 170% in San Francisco since the law was passed. Sex work again has been driven offline and into underground areas, and harm reduction tools have been deleted from the internet. A lot of what sex workers did is, as some of you know, they would use the internet to be able to share information and safety tips and bad date lists and harm reduction tools. A lot of that has been eliminated or is very difficult to find now. We see sex workers reporting a willingness to take greater risks to survive, do things that they otherwise wouldn't do in interactions in the real world, to be able to make a living and continue to operate with in the absence of the internet. And we also see consensual prostitution now swept up in trafficking investigations. So you see a lot of these investigations that are purportedly launched for the purpose of investigating sex trafficking, which ultimately produce nothing but prostitution arrests. We saw that in the Kraft case in Florida, for example, and the reviewboard.net in Washington is another example, which a lot of federal money is going into investigation of sex trafficking at the local levels. They're flowing money into the local police departments and state investigative agencies to investigate trafficking, but there's not enough trafficking to investigate, so they end up with arrest for prostitution. So the sex workers are taking the brunt of this, as we have seen, and particularly in marginalized communities. And so the people that FOSTA was supposed to protect are now bearing the brunt of this and being harmed the most.
And as a policy matter, it's a really heartbreaking misalignment of priorities and sort of strategy for how law enforcement could be doing better to protect more people. There was a really great study by an economist at Baylor University, Scott Cunningham, who looked at historical data around when, this was from 2002 to 2010, looking at when Craigslist, as it was just coming online and moved from being a San Francisco thing to a nationwide and then global thing, looking at the kind of what happened to rates of female homicide in a city when the Craigslist erotic services section kind of came online and was available to people engaged in sex work to do their solicitation online and client screening online and all that sort of thing. And he found that pretty much across the board between a 10 and 17% reduction in rates of female homicide after Craigslist was available in a city. Now it's correlation, not causation, but it's a pretty strong, pretty consistent correlation that at least deserves more investigation and more thoughtful, if you could think of no higher purpose for law enforcement than to reduce the rates of homicide, and doing things that are directly counter to that and that don't actually necessarily address the problems that they say they're trying to address. It's so frustrating that the policy debates are so skewed towards the content is bad, the content must come down, and maybe as an afterthought, possibly we think about people's lives.
Exactly. And so we think about what is causing this, what is fueling all of this, and as far as I'm concerned, there's a few myths out there that contribute to this anti-sex work, anti-prostitution, anti-trafficking movement. Myth number one being that criminalization of prostitution works. And as we've seen, just with basic prohibition efforts, it doesn't work. And in fact, the more criminalized the activity is, the more that the sex workers actually suffer. We've seen studies that show that the more criminalized the activity is, the more likely it is that the sex workers will be victimized by law enforcement. Myth number two is that all prostitution is sexual slavery, again, conflating sex trafficking with prostitution when we know that they're vastly different activities. Number three being that sex trafficking is fueled by the proliferation of pornography. Last year we talked about a study that was commissioned by the Department of Justice, essentially for the sole purpose of concluding that pornography fuels sex trafficking by making viewers less sensitive to the plight of sex trafficking or something. So after a long study, the surprise result is that pornography fuels sex trafficking. So now they have a justification to essentially conflate the concepts and use anti-trafficking efforts to pursue pornography censorship. And then finally, decriminalization is harmful is the final myth, and we know that through numerous studies in other countries that decriminalization leads to fewer negative effects to both the health and the safety of sex workers. And so you have these misbeliefs out there that are fueling the narrative and resulting in more and more consideration of new laws to attack consensual sex work and also to censor online communications. I do want to save some time to talk about the Woodhull case, which Ronnie and I are handling. Thank you. Appreciate that. As many of you know, we've launched litigation against the United States and the Department of Justice and are challenging FOSTA on numerous grounds. we've had some rulings. And so, Ronnie, why don't you take us through where we're at now and what's happening next month?
Right. So the Woodhull litigation is what they call a facial challenge to the statute. That is, arguing not just as it's applied in certain contexts, but rather the statute as a whole is unconstitutional on its face for a number of reasons, one of which is the chilling effect that it has. And part of the reason it has a chilling effect is because its terms are vague and overbroad in terms of what it means to facilitate prostitution. I mean, look, you can say, I know what it means to facilitate something in the ordinary course, I mean, generally speaking, but generally speaking isn't precise enough when you're talking about the First Amendment. You have to know exactly when you are going to violate a statute under the First Amendment, or it is not drawn narrowly enough and specifically enough to survive constitutional muster. And facilitating is a very, very squishy word. So you've got the facilitating prostitution 2421 violation. As Emma mentioned, they had previously amended Section 1591, the federal anti-trafficking statute, to add advertising as an offense. Now they have added the what's the language from the new definition? They've redefined essentially the knowledge requirement for advertising prostitution with knowledge. That's a problem. The fact that there is retroactive application is a separate constitutional problem.
Reckless indifference.
Reckless indifference is too low a scienter standard of knowledge. And so we have brought a full frontal, so to speak, challenge to the statute. We brought it before Judge Leon in the district court. The government came in and basically said, well, we're not really doing anything all that different from what's already criminalized. You know, you've got the Travel Act. The Travel Act has always been used to target bringing people across state lines for, illicit purposes, including prostitution. The scienter is the same. No one's ever said that's unconstitutional. You always have to have specific knowledge of the specific individuals being trafficked. And if you don't have that, then you're not going to be criminally liable or civilly liable. And therefore, you don't need to worry about it. And so our plaintiffs are all, like Woodhull, entities who were concerned that they could get swept up in a criminal prosecution or a civil litigation alleging that they are facilitating prostitution or facilitating trafficking. And the government's basic response was, you don't need to worry about it. You're not in the zone that we're targeting, and therefore you don't have standing to challenge this. And we tried to explain to the court that the problem isn't just whether you are ultimately liable. The problem is that by being this vague and being this overbroad and being so unclear and newly allowing civil liability by trenching back on Section 230 immunity, you're creating an incentive for, I don't know, is crusaders too, not a fair word, but for crusaders to bring lawsuits, not just because they think they can win in finding you liable for, facilitating sex trafficking, but because simply the cost of defending the lawsuit itself will stop you from doing what they don't want you to be doing. Unfortunately, Judge Leon kind of went with the government on this and said, no, none of you have alleged that what you want to do falls within the prohibitions of FOSTA, and therefore you don't have standing to bring this challenge, and I'm dismissing your suit. We have appealed that to the Federal Appeals Court in D.C., the D.C. Circuit. The case has been fully briefed. There's going to be an oral argument on September 20th in D.C. Circuit. Bob Corn-Revere in my office will be arguing that. Hopefully within a matter of months after that argument is heard, we will have a decision. Hopefully we'll have a more receptive audience among the three-judge panel at the D.C. Circuit.
Well, and one of the most surprising things about the Judge Leon dismissing the case, like one of your plaintiffs actually lost the venue for doing his business because Craigslist shut down their section. Right?
And the business, by the way, was being a masseuse. And not being a masseuse in the kind of euphemistic way, but an actual, masseuse. And he traveled around the country, and in order for him to advertise his services in a way that would facilitate his travel and being able to be hired in the various places he, would pop up, using a nationwide online service like Craigslist was particularly important. And they didn't just shut down the adult section way back when. They shut down with FOSTA the connection section, the dating section. And when they realized that dating could, be moved over to services, they shut down certain services, therapeutic services. And so he lost his platform. And even that wasn't enough to convince Judge Leon that the incentives created for online intermediaries was enough to harm the individuals who were bringing the suit to give them standing. I've never seen anything like that before. Generally speaking, particularly when you bring a facial First Amendment challenge, you can be bringing it on behalf of yourself and others similarly situated, and even that wasn't enough to convince Judge Leon. I think he was a little bit cranky with the timing of the whole thing. I think he has his own issues with suits that are in this milieu. We've had an obscenity trial before him that he grudgingly had to dismiss the charges in. But like I said, we're up on appeal now. Hopefully we'll have a receptive audience in the panel.
Well, we have a strong list of supporters, as you see on the slide, that are called Friends of the Court or amicus curiae, and a large group of supporters have sought permission from the court to appear and submit briefs in support of our position. And we have technology groups and academics and sex worker outreach programs and a strong group of folks that have come together. We're very proud of the briefs that were filed and the issues that were raised. One of the great things about amicus briefs is that they can get deeply into issues that we as the parties can't address or don't have the space limit to address. You're greatly limited in the number of words that you can use to make your arguments in an appellate brief, and every word counts, and so we have to focus exclusively on the most important issues. But the Friends of the Court who had lined up to support us were able to explore the First Amendment issues in more depth and the impact on technology and service providers and innovation and so forth. So we think that all the arguments have been put out there. The judges, or at least their law clerks, will read the briefs and hopefully be influenced by the arguments that were raised. The Center for Democracy and Technology also filed a brief in support of us, and so maybe you can tell us a little bit about
well, let me just add before you go there,
okay.
What you don't have listed on there is the amicus support that the government had.
Well,
You had
yes.
who were, I don't think this was their role, their intent, but they were tremendously helpful to us because you had the state attorneys general coming in saying, yes, exactly, this is exactly what we need. This is exactly the authority we need to enforce this. You had the advocates coming in saying, yes, FOSTA is needed because we need to shut down all of this stuff. We needed a tool to go after these types of things. They were fantastically helpful to us, even though they were filed for the other side, and they're not listed there. But anyway, let's talk about the CDT
basically
brief.
Basically just saying, we plan to bring lots of lawsuits against websites. And I was like,
Yeah.
that is in fact what we're afraid of, yes.
That's right. That's what we're arguing.
Yeah, so CDT played one of the roles that Larry was describing of, I think the plaintiff's brief mentions that FOSTA is one piece in a long history of Congress trying to censor adult-oriented content online, going back 20, 25 years now, and they had about a sentence or two where they could reference it, but we had another 20 or 25 pages. And I won't go through the whole long litany, but the brief's on our website, and encourage you to take a look if you want a sort of depressing Groundhog Day sort of experience of, at first, the first thing that Congress passed basically about the internet and online content was the Communications Decency Act back in 1996. This was a law that was about limiting, requiring websites to ensure that minors were not accessing pornography. And this was a kind of a distinction that Congress kept trying to kind of bring up for the next 10 years or so in different pieces of legislation because adults have every constitutional right to access pornography. It may, as long as it's not legally obscene, and that's a pretty high bar, adults have full First Amendment rights to access this material. States can limit minors' access to the material. So for people under 18, and there are different tests that the Supreme Court has developed about what is a permissible kind of limitation that a state can put on minors' access. And so a lot of the theme in congressional activity around sex and pornography and sexually explicit material online has always been about, what about the children, and can we limit children's access to material that some people in Congress think is inappropriate for them. The big answer that the Supreme Court came down with in '97 when it struck down most of the Communications Decency Act was, this is actually really complex, and it's not the same choice is not right for every minor, for every family. The much better option is for what they called like parental control tools, or essentially, filters on your home computer, not filters in the middle of the network, limiting everybody's access to content. And that decision by the Supreme Court has stood in very good stead for for the 20 plus years that it's been in place. There have been a couple of different efforts that Congress and some of the states have raised to try to sort of wiggle around it, or wiggle around the idea that, well, it's okay if we have an overbroad limitation on access to pornography online. But the times that it's come before the Supreme Court, they have been pretty clear that the internet is an amazing enabler of freedom of expression, and that, kind of overbroad and ham-handed laws by Congress are really jeopardize that in very meaningful ways that the Constitution won't permit. So, I'm not sure when FOSTA will and the Woodhull case will get to the Supreme Court, but I wouldn't be surprised if it does happen. And fortunately, there we have pretty good jurisprudence and case law respecting our First Amendment rights.
So, yeah, I mean, it'll certainly get to the Supreme Court if we win in the D.C. Circuit, because anytime a federal statute is invalidated on constitutional grounds, it almost is a ticket to certiorari.
Yeah, and that's kind of the content of this next slide is, what might happen in the case next, and we get asked that question quite a bit. So, the options are essentially this. The appellate court can reverse the trial court's ruling and actually enter the injunction and put a hold on FOSTA. That would be, the slam dunk win, and we are obviously hoping for that. That's what we've asked the court to do. The appellate court could also reverse the decision on standing and determine that, yes, we do have standing to pursue the lawsuit, and then send the case back down to the district court for a resolution of all the constitutional issues, potentially a trial, additional evidence, hearings, etc. So that's an option. The court could also affirm all of the district court's decisions, saying we don't have standing, dismissing the case, and then you'd have potential motions for reconsideration depending on what the court rules. You can ask the appellate court to reconsider their ruling. You can ask potentially the entire appellate court, called an en banc hearing, all of the judges of the court to reconsider the ruling, or either side, as Ronnie mentioned, could go up to the United States Supreme Court. If the statute is invalidated, we expect the government to appeal. If we don't prevail, we expect to be able to appeal to the Supreme Court. And these are important issues. These are critical First Amendment issues on a brand new statute that hasn't been interpreted before. So, there is a real potential for Supreme Court appeal. I'm sorry, was there a question in the back, or are you just stretching? Would there be a potential for other participants in the suit if we are reversed on standing? If we're reversed on standing, then we would win. Now, if you're talking about if the case is sent back to the district court, could other people join in? Potentially, it would. The judge in the district court could decide on whether or not to allow us to amend the complaint if we decided that we wanted to bring in more plaintiffs or something like that. The existing plaintiffs that we have, we think, cover the watershed in terms of all the different kinds of arguments that could be raised. So I think that the parties that have been assembled are sufficient to be able to make the arguments. There's always a potential that somebody else could challenge the statute at any time. And that is something that we would watch out for. If anybody is actually prosecuted, if any platform is the subject of a criminal charge or even sued civilly, they would then clearly have standing to challenge FOSTA. And so that's a possibility too. If the government decides to enforce the statute, or if a private party decides to sue somebody, then that case could raise these issues and there wouldn't be any standing question.
And that's one of the real problems with Judge Leon's decision, and that is he basically is saying, if when you cut through it all, unless you're prepared to come into court and say, I am violating the statute and I intend to violate the statute, you don't have standing to challenge it, which, certainly you would be in the dead heart center of standing. That would be true. But to say, hi, I'm violating this and I want to challenge it, no one's going to admit that. The whole point is, when you talk about a vague and overbroad statute, is I don't want to violate it, but I don't know how to avoid doing so because it's too unclear. I should have standing to say, I need an interpretation from court. Either you're going to tell me how it's going to be interpreted, or you're going to rule that it's too unclear and uncertain under the First Amendment to survive scrutiny. We have a question in the back.
Breaking other laws to come in and say, hey, I've had to my entire job. Or actually, I think probably the most obvious example would be the Desiree Alliance. I don't know if you're aware of this conference. It's a harm reduction conference that's oriented towards sex workers that was canceled last year in the wake of FOSTA SESTA. I mean, that would seem to me to be such a no-brainer in terms of hitting the nail on the head. I guess I'm just wondering, like, what about, you have all these amicus briefs, but what about one of these harm reduction organizations? Wouldn't they have more obvious standing?
If we could just get you on the federal bench, we would be so solid, because we said that directly to Judge Leon. We said, look, Woodhull, after Desiree Alliance announced that it was going to not hold its conference last year in the wake of FOSTA, Woodhull considered allowing them to hold part of their conference in conjunction with Woodhull's conference last year. And Woodhull also felt like, well, we really don't feel comfortable enough under FOSTA to allow that to happen. And we put that all before Judge Leon, and even that wasn't enough for him. I mean, what you're suggesting, look, I think that all of our plaintiffs have standing, okay? And I think you probably think all of our plaintiffs have standing. But if we're starting from the proposition that they might not, your suggestion is, if you're a sex worker advocacy organization saying, hey, could very easily be accused of facilitating prostitution. Well, we have that plaintiff, right? SWAP is that plaintiff in our case, and that wasn't enough for Judge Leon. And again, I think he's wrong, but what he is basically saying, not in so many words, but the net effect of it is, you've got to come in and say that you are planning to, or you are violating the statute. And even sex worker advocacy organizations don't want to admit that, yes, what we're doing does facilitate prostitution, not because it doesn't, but because if for whatever reason the statute is deemed to be constitutional despite that, there's already an admission on record that they're violating it. I mean, it's the wrong incentive.
Or it makes you vulnerable to state legal claims. And that was something that when we were talking to different folks considering whether to be a plaintiff in the case, that kept coming up, of people saying like, and I think it could be a great, rock solid case against this federal statute, but I'm also still bound by the laws of Massachusetts or Kentucky or Louisiana or wherever, and having on record, an affirmed sworn statement of activities that you engage in could create a lot of other jeopardy.
Yeah. One other just quick mention on the Desiree Alliance issue, and we wanted to bring that up in our case, and we did. But remember, FOSTA requires that the promotion or facilitation of prostitution occur on an internet platform or internet service provider. The mere cancellation of a conference without any reference to an internet service provider or platform wouldn't trigger a FOSTA problem. And so that's why, when the conference was canceled and couldn't then be hosted through Woodhull's website, that's why it became an issue in the Woodhull case. On its own, the cancellation of a conference wouldn't trigger a FOSTA issue.
I appreciate that nuanced response. I think that was really excellent. And also, when you're in a position to put me on the appeals court.
I'll put in your application right after mine.
Let's see it. We got one here.
Oh yeah, please wait for the. I guess we have the
Take
mic.
one here, and then we'll get
please
over
wait
to
for
you
the
guys.
mic and identify yourself when you get it.
I'm Carol Lee from San Francisco. I'm part of the mayor's anti-trafficking task force as a sex work and trafficking policy impact committee. We got the trafficking task force to object to FOSTA SESTA on record, so that was good. But my question to you. My question to you is, in the course of organizing around this, the other side was complaining that they really loved that, the aspect of it where they could sue people. And, you know, as America, you want to sue. And so my question is, looking back at like the anti-porn legislation, Dworkin-McKinnon, and all the anti-prostitution legislation I've seen through these like 30 years, 40 years, it's all about this suing. I want to have a little bit more information about, I heard you saying that suing is bad, it's very debilitating, but do you have any kind of general comments about that whole way? It's historically a huge factor in anti-prostitution, anti-porn legislation.
Well, I can say this. I mean, I am doing most of the civil defense work of the former principals of Backpage. In the wake of the criminal indictment and the shutdown of the website, the seizure of the website by the federal government, there have been about 12.5 civil lawsuits brought around the country. And I can tell you that, for example, in the Texas case, in response to the Section 230 defense, the response has been, FOSTA changes everything. Not only does FOSTA newly allow a civil lawsuit for victims of sex trafficking under Section 1591 and 1595, which is the federal sex trafficking statute, which is in fact what FOSTA says. But because the language of FOSTA is no state law or cause of action shall be brought that is inconsistent with this statute, that's what really protects you from civil liability in the courts, because there's no federal tort violation per se. All torts, all personal harms come in under state law. They have said that, well, FOSTA didn't just allow these federal civil suits under this one specific statute. Anything that is related to trafficking, whether it's a negligence claim, whether it's a failure to warn claim, whether it's a product liability claim because you designed your website the wrong way, all of those are allowed now because they're no longer, quote unquote, inconsistent with this section. The threat of this kind of civil liability is very real. It's very expensive litigation. If you can't get out early on a motion to dismiss under Section 230, the discovery that these litigants seek is not just, okay, so this is my advertisement and we want to know what happened to it and how you allowed it to go forward. They want to lift up the hood and take apart the entire engine and see everything that your website does, how it does it, what its measures are, why they're not successful, why they are successful. It's a very expensive and intrusive proposition. So this threat of civil litigation is very real and is a significant disincentive for intermediaries to allow this kind of content to go forward under FOSTA.
And as you mentioned, that they've done the same kind of thing in the anti-porn efforts, right? And so Utah has recently passed a law that allows any viewer of pornography to be able to sue a distributor or producer of pornography if they are exposed to pornography and if it causes mental distress. So that's where this is going now in terms of incentivizing lawsuits. I don't know how one proves that they've suffered mental distress as a result of viewing pornography.
Oh, you live in Utah. That's the first step.
Well, maybe it's a really bad production. You spent $50 for
voluntarily
it,
live in Utah. That right there is prima facie case.
But, and it's the same kind of thing. It's to debilitate the companies. It's to force them to defend lawsuits, even if they're unsuccessful, even if it's a bogus claim. It's just to drive them into the ground through the cost of litigation and defense. Let's get some questions over there. Yes, in the black shirt.
Hello. First of all, thank you for the work you're doing. It's extremely important for all of us. My name is David, and I'm the co-founder of a non-fictitious service provider called #Open. My career, starting in 1994, was protected under 230. I've been an internet service provider in many forms since that time. We have an application with 25,000 people here in the US using it. It's free, so there's no commerce involved, but our business model is eventually to try and collect some modest amount from end users to run it as a business. And we have this very real catch-22, which is we know that people are communicating about all sorts of things in our app, and inevitably some of them are having sex. how do we move forward in this regime? And I'm not looking for free legal advice, but
Yeah,
what do we do?
You're basically in the same position that all operators are that allow third-party content, particularly those that have any kind of focus on adult content. They're in the crosshairs because they can be alleged to have solicited this particular type of content or know that it's there. I think the best thing for you would be to maybe consult with one of us afterwards, talk a little bit. Hate to get too deep into your specific circumstance, but you're in the same position everybody is in. You're trying to figure out what to do to try to comply with the law. You want to comply with the law, presumably. You don't want to do anything illegal. But as we've said to the court, we don't know what compliance looks like. This law is overbroad. It doesn't define prostitution, doesn't define facilitate, doesn't define promote. We don't know what we have to do. Tell us. And that's what we're trying to get an answer to.
Well, and here's the great irony is that, Section 230 has two parts to it. One is that if you publish third-party content that harms somebody else, you can't be liable as the publisher of that content. The other part of it that gets looked at a little bit less frequently is if you do engage in this part of the statute, it is a good faith effort to edit or to kind of actively filter, you also can't be responsible for that as well. And by taking away that immunity, the incentive you're creating is I'm going to put up a platform and it's going to be the Wild West. I'm not going to look at anything. I'm not going to make any effort whatsoever. You're not going to be able to charge me with knowledge because I'm not even going to look at it. Well, that's fine until somebody comes along and sends you a letter saying, here's all the stuff on your site that's illegal, and that's how we get back to what we were talking about before, the heckler's veto, where you have no choice but to take it down. There is no good solution with FOSTA because we don't know what a violation looks like Larry says.
And it creates a pretty crappy user experience because it means you're not doing content moderation around anything from harassment or hate speech or whatever else your community on your service might want you to do. Maybe everybody just wants you to stay on topic and take down any discussion of politics or something. But this is the tension that Section 230 was originally intended to address, not discourage that kind of good faith moderation, whatever it may look like on a given platform, and enable people to address content that they don't want on their service, but shouldn't incur liability because they happen to review material that gets reported to them.
And finally, your opponents or the government will argue that you're engaged in willful blindness, that you're not paying attention to any of this, so you should be charged with knowledge anyway. So it's a true catch-22. Real quick, there's a link back there on the slide to the link that has all of the information about the Woodhull case. We post it frequently. Otherwise, you'd have to go to Pacer and download the documents and pay for them and so forth. Everything is there as it happens. So if you're interested in following the case, please feel free to keep track of that link. I saw we had a question on that side, and then we'll go back to the
mic's over there.
The mic's
already,
over there?
so yeah.
Okay. There, and then we'll go.
JJ from the Skyward Foundation. Your list of amici curiae included one platform, Reddit. What kind of reactions, if any, did you get from other platform providers who either were approached or who said, we want no part of this?
Hey, Emma, why don't you tell them about what the other platform companies did in the lead up to FOSTA's adoption?
Well, yeah, so the legislative fight around FOSTA SESTA was pretty remarkable because it was one of the first times that there was in multiple efforts in Congress to create new liability around user speech, that there was a real kind of breaking point between some of the online platforms and the digital rights activists and the free speech groups and everybody. It had been a very strong coalition opposing these sorts of things because of the combined impact on individuals' free speech rights and the risks for the technology industry. The trade association, the Internet Association, which is a trade association for some of the biggest name platforms, including Facebook and YouTube, and a lot of other kind of the biggest online properties, actually ended up supporting SESTA. And then there was it gets hard for me to remember exactly who supported what pieces of SESTA and FOSTA, or the combined bill that just literally combined two different bills into one thing, and that got passed into law. But it was, Facebook COO Sheryl Sandberg was out there like actively supporting and promoting the bill because she felt very strongly that sex trafficking was bad. I'm pretty confident that every single person on the opposition to SESTA FOSTA thought sex trafficking was bad. But so we saw some of the biggest online platforms actually end up supporting the law, and I don't think any of them were really interested in getting involved in the lawsuit.
Well, and here's the problem with a statute like this, is that you get to a point where public sentiment is trending a certain way, and it gets us enough of a momentum that the larger, well-established companies, and I'm not going to name names, but we know who they are in the online ecosphere, they're well entrenched, they have a lot at stake, and so what really happens is the new companies that might start up and challenge them, it becomes that much harder for them to start up because of this potential liability that these other companies can weather. So not only does it become an opportunity for the larger companies to look like a good public citizen, it also, and I'm not sure it's intentional like this, but it does serve to re-entrench their ability as the large incumbent. And then once you give your support to a statute like this, it's very hard to then turn around and join the legal challenge trying to take it down.
But one other amici I think that was on the list was a group called Engine Advocacy, and they're actually a trade association for startups. So it was also this interesting split in the fight around SESTA FOSTA between, just as Ronnie's saying, some of the biggest interests who were probably pretty correct in their assessment that like DOJ is probably not coming after them. They may, I don't know about the state attorneys general, but at the very least, a lot of the bigger platforms feeling like whatever this turns into, maybe we can survive it. But the startup community was much, and remains kind of much more engaged in fighting back against this law.
It's worth mentioning that a platform is one of the plaintiffs as well, archive.org, the Internet Archive, so they did join in the suit, and so we have them represented. And there's one final comment on the Internet Association and their kind of change of heart. You have to remember that at that time they were catching heat on the Russian interference issue. And it's very curious timing that as soon as Congress started coming down on them, they gave in on this issue. And so there's a lot of political wrangling, I'm sure, going on there. But it was a hard time for the online platforms when this was all occurring. Yes, you had a question.
Yeah, so I did have a question. Hi, I'm Sophia Vivana. So for platforms that do remain for advertisers to use on, such as Eros, there have been concerns about privacy breaches. In order to advertise, you have to take a picture with your ID, like you had mentioned, and submit it, and then you can use this board. So when they have privacy breaches, what kind of individual ramifications do we face through the lens of FOSTA?
Well, I mean, any online platform that allows two people to connect has the potential to be used for prostitution, for sex work, and this is why Craigslist, having already taken down its adult section, then took down its dating section, then took down services. I mean, there are websites out there where you have the democratization of the internet. You've also had the democratization of pornography, where once upon a time were the performers have taken over the distribution and creation of their own content. They're able to make one-to-one or multiple audience connections and viewer connections. That could very easily lend itself to not just the selling of content, but to the selling or invitation of services. And it's the same problem we were talking about before. Once you allow that kind of connection to occur through your website, you either have to basically watch everything and put a stop to anything that's even potentially questionable, or you are subject to notice liability, or you whistle past the graveyard. The users? Well, I mean, the users, I think you would face, if you are in fact conducting sex work over the platform, you would face the same kinds of potential liability as if you're conducting sex work, offline. It's a matter of would you get caught, right? I mean, it's the same jeopardy that you face, in the brick and mortar, if you can put it that way.
So because FOSTA SESTA applies to online platforms, that law may not directly increase risk to any users of sites. But I mean, you raise a really good point about the risk that these kinds of identity or age verification policies create for the users of platforms. You know, this policy may actually be more in response to the United Kingdom law around identity verification of users. But it's something that we see time and again where, you know, and it goes all the way back to the mid-90s when Congress thought, we'll just make adults give identifying information in order to access pornography, right? Again, it's like constitutional right to access this. Everything is perfectly lawful. And one of the big arguments that I think convinced the court to strike down the law is that it actually really jeopardizes people's privacy and can have a chilling effect on your willing to access lawful content or to engage in lawful speech if you're told you need to provide identifying information to this website, and fingers crossed they don't have a data breach, right? Fingers crossed that there's not like some record of here's your, you know, photo and your address and your date of birth and your full name, because there's your identity stolen by somebody who wants to, along with, you know, a set of your behavior, your activity, or what you viewed on the website. The risk to individual privacy of those kinds of policies of having age verification, identity verification, especially when it involves like a government issued ID, are really high and can actually have a chilling effect on people's access to, you know, totally lawful content and lawful speech.
And remember the Ashley Madison data breach, right?
Well, and you know, and FOSTA requires in a lot of ways this robust verification of their users if they're trying to weed out trafficking, because, you know, trafficking is defined as either underage, so IDs can prove how old somebody is, or coerced or defrauded or forced individuals. Well, you're trying to weed out people who have their IDs taken from them and are forced to engage in sex trafficking. If you're actually producing your own ID, then there's at least a belief that you must be a valid person who is consensually submitting the ad to the online platform. So, you know, that's how a lot of those policies related to identification on the platforms have developed, is in direct response to the new risks that are created by FOSTA. Do we have other questions in the room? Yes.
You all spoke a lot about, there's a lot of mystery behind this because they haven't defined it well. But for those of us that are trying to create a startup or a blog or something sex positive, is there a place we can go to find web hosting sites, banks that are still sex positive, that are still trying to work with our community? And then what can we do as individuals, as sex positive people, to help support these businesses and to help support our community?
Well, you know, I don't have a specific list for you. You know, those that are sex positive often don't advertise themselves that way, and it's more of a word of mouth thing. You know, I would encourage you to talk with others in the industry, even industry attorneys, others that you know, that mix and mingle. Go to events, go to adult entertainment events, because the service providers tend to also go to those events. But you don't see, you know, open advertising directed at the adult entertainment community because of, you know, the stigma that the community has unfortunately developed at this point, and the risk to the online service providers. So that's the best recommendation I can have for you in terms of finding service providers.
And support for the lawsuit challenging FOSTA is always welcome.
Indeed so. And there's the link right there to support the lawsuit. Do you have any other questions? We've got about 5 minutes, so we have time for maybe one or two more questions.
I do want to say something. I have considered FOSTA to be the camel's nose under the tent, but I changed that to the canary in the mine, except in this case, if the canary lives, the eagles are going to come after it. I honestly believe that if this law stands, we're going back to the dark ages.
Well, and then you're right, and this is one of the biggest problems with FOSTA is from the time that Section 230 was adopted as part of the Communications Decency Act, right? You had the whole harmful to minors, you know, restrictions, prohibitions, all that gets struck down. The only thing that survives, ironically, is Section 230, the safe harbor immunity protection. Every time in a lawsuit, when you're arguing about 230, and it's, you know, especially if it's sexually oriented material, The other side is always saying, this whole statute was about keeping this kind of stuff out of the hands of children. It was about, restricting stuff in the first place. What are they talking about? Which is bullshit. You had this other statute and this section got added to it, but it was always intended to be protective. And from the time Section 230 was enacted as part of the Communications Act until now, you're talking about the better part of 25 years, until 23 years before FOSTA was enacted. You had federal criminal liability, all state liability, criminal and civil, was immune. All federal civil liability. There was nothing that anyone could do to you except for the feds coming after you. And by allowing FOSTA to be the first chink in the armor of Section 230, if it stands, it becomes the model. And there are bills and hearings being brought through Congress now to, what do we do about the deep fake problem? Well, here's what we do. We'll take away the 230 immunity, and then the publishers will have to be responsible for policing it all. What do we do about the hate speech problem? Well, we take away the Section 230 immunity, and we make the publishers keep the stuff off of their sites and make them monitor it all. And it just becomes, once you break that dam, everything else becomes fair game. And that's why this is a really, really important legal challenge.
Would you tell people again, please, since you're on the video and I'm not, where they need to go to support this lawsuit?
The URL is right up there. Are the slides posted? Yeah, so the slides are posted. Is this the last slide, or are there?
It can be the last slide. Yeah,
I'm not saying make it the last. I'm just want to direct them to the right slide.
Yes, this is not the last slide, but this is the link, so we have it on audio as well. It's woodhullfoundation.org/r-work/FOSTA, FOSTA. So that's where you can go to find out about the suit, as well as to donate to our defense fund efforts. Any final question?
One more.
And then we'll wrap it up. One second.
Before FOSTA went into force, PayPal was taking client money once it was being transferred to, for services, and it was being shipped into the Department of Justice, Department of Treasury. So I know it's really strange, and hardly anybody even knows about it. But I tried to engage services from somebody in New Zealand, and when I sent the money to New Zealand, it was flagged by PayPal. It was sent to the Department of Treasury, and I had an amazing amount of hoops to jump through in order to get my money back. Meanwhile, I still had to replace also the money that was in New Zealand, because the gentleman didn't get the money over in New Zealand from PayPal. So I want to know, and this was in 2017. So my question is this a money driven for the Department of Treasury? Because it was already being money driven before FOSTA went into effect. And like I said, I don't know how much money of clients that were doing all of, because the clients, they don't talk much in any of this situation. So, but I don't know has anybody considered that this is a financially driven situation in order to put more money into the government?
One of the
it's like, forfeiture. It's like forfeiture.
Yeah, well, that's absolutely true. FOSTA does have potential criminal penalties, financial penalties. The law allows for lawsuits so that plaintiffs' lawyers can sue for not only damages but attorney's fees. So that is a huge incentive to force the online platforms to take down content that is anywhere at the borderline. And in a lot of ways, everything's about money, and there is a significant financial component to the incentives that are directed at online platforms to take down any content that potentially promotes or facilitates prostitution. Any further comment on that, or?
It just makes me think of one other point to kind of close with, which is it's a very good point that things weren't all hunky-dory online before SESTA FOSTA, right? And that we have the questions about kind of whether platforms are willing to host sexually oriented content or sexual expression online have been big struggles, going back decades, obviously. There was actually just a lawsuit brought last week with a group, a class action, but led by Divino as the named plaintiff versus YouTube, alleging kind of systematic discrimination against LGBT individuals through their content moderation policies. And so it's an interesting suit to take a look at. It documents what was, I think, already pretty apparent to a lot of people, that a lot of YouTube's policies disproportionately impact the LGBT community. They're bringing claims that are, state-level constitutional claims and Unfair and Deceptive Trade Practices Act, and I think they bring a federal claim along those lines as well. Almost all of that is almost certainly preempted by Section 230. It's not, just in my view, it's not likely that this lawsuit's going to be able to gain any legal traction, but it does point to a really important issue, which is that for a lot of people, the way content moderation works on a big platform can be extremely important to their business or to their financial livelihood. It's not nearly as transparent as it could be. The motivations behind a company when it decides your account has to come down or your content's getting removed can be completely mystifying to the average end user. So CDT and a number of other civil liberties groups have been pushing the companies to be more transparent, to do, and to also evaluate the impacts of their policies. If they say they don't want to have a disproportionate impact on different groups and that they want to be welcoming to LGBT individuals and all of that, there's a lot more that they need to do. But it's really important, I think, to think about what is it that kind of we as a community and what different communities can do to push the companies to do better versus what happens when you have a law like FOSTA on the books that gives kind of anybody the ability to bring a legal claim that might shut a website down entirely, and that there's a kind of a broad range of kinds of advocacy tactics that you can take, but that when you start getting legal decisions and laws like FOSTA on the books, you sort of stop the opportunity for there to be a diversity of platforms for a diversity of voices and perspectives, and end up with kind of the horrible future that Ricky outlined for us.
Well, on that positive note, that was actually a really good summary, Emma, and appreciate it. Thank you all for coming. Appreciate your time and efforts. Support the lawsuit. Support Woodhull. Thanks again for coming.